follows right along perfectly. It's going to be handled by Eric Landry from Brazil. This is on the buyer representation agreement. Every broker should have received a copy of the template that was developed by Brazil. We asked for feedback, we received some, they made some modifications. So Eric, I'm gonna let you talk about that at this time.
All right, perfect. Thank you, Rhonda. And part of what my presentation was gonna be was a lot of what Matt covered in terms of why this agreement's appropriate, why you should be using it, and again, kind of like the purpose behind it. I think Matt probably could do a much better job of explaining to you the importance of this agreement now, especially in light of the litigation that's going on. But that doesn't change the fact that these agreements are beneficial and have been, as somebody mentioned, they've been using it for 30 years to protect a broker and agents in relation to buyers who they represent, and then also to protect the buyer, to make sure that the buyer understands what they're getting and how much they're paying in exchange for those services. So I'll kind of, gloss over why we're doing it, since Matt's done a good job of explaining that, and kind of go into the form of the agreement. As Rhonda said, we started by really looking through lots of other state and local associations forms, and some local brokers here in Louisiana that provided their forms. And so we went through lots of different forms to try to boil this down and try to come to what we consider to be hopefully a fairly simple, because there are some versions of this that are much more complicated, some that are slightly simpler. But what we wanted was something reasonable that wouldn't be overly burdensome and you having to explain it to buyers, or for buyers to understand, and wouldn't, sort of bog down the process of getting them signed up. So that's how we got to the form that we got to, is by using all those forms and amalgamating that into what we came with. Moving into the form itself, one of the comments we had was, originally we had just named the buyer and the broker. People commented that we need to add a designated agent so that the buyer knows what agent within that brokerage they'd be dealing with. And so we did add a line at the very beginning, so you can designate a designated agent if you find that to be appropriate. That, is not required. And let me back up for one step to be clear. This is a form that's being provided, as a service to the members. This form can be edited, revised, however you see fit, and used however you see fit. So if there are changes you want to make to this form, you are free to do so. This is not copyrighted or mandated. It's not required by the LREC. I think, as most people know, this was purely being provided, as a member benefit, so that you have something you can use to have a buyer representation agreement in place, and or to use this as a starting point to draft an agreement that fits for your needs. So again, you can designate a designated agent. We did, put in at the beginning, what is the purpose? Why is buyer engaging this broker and this agent? We did put in a blank that kind of tries to leave open the possibility that you're describing the type of property that the buyer is interested in. Again, some people had some questions about whether that's appropriate, because it may be difficult. If in your context you don't think that it's necessary to have that, you can certainly remove that. But what we tried to do is say, hey, look, if nothing is designated, then we understand we're talking about residential property, and leave it kind of general in that regard. But if somebody knows they're looking in a particular city, knows they're looking in a particular neighborhood, school district, or whatever the case might be, this would be the place where you could maybe identify with some specificity type of property that the buyer may be interested in. Our agreement is an exclusive agreement, meaning the broker and the buyer agrees not to hire any other brokerage, right? This does not mean that you have to have an exclusive agreement. You could have a non-exclusive, but in most of the forms we looked at, it was exclusive, and we think that's the more typical type of relationship that you're going to have. So that's why we created the form in that way. We clarified that this creates, an agency relationship, and that, as an agent, you're responsible for complying with all the duties under applicable law. and laid out some of the statutes that dictate what the duties of an agent are. And these are all the same ones that you're familiar with, and we're not adding any responsibilities or obligations on any agents or brokers by making reference to those. Those are things that apply regardless. We try to define who is the broker, who is the buyer. Obviously, buyer could be multiple people if you've got, husband and wife or co-owners or potential co-purchasers, let's say. And then we talked about what is a purchase, and we kind of tried to expand upon more than just your typical acquisition of a home through the standard, cash sale process. Designated agent, again, we kind of touched on that above, but here's the opportunity to you, if you would like to designate an individual who will be the designated agent. And that being said, we reserve the right for the broker to substitute someone. So if the designated agent quits, leaves, or whatever reason, has a bad relationship with the buyer, the broker can designate someone new for that buyer to deal with if they want to. We also make reference to this is kind of a reference to applicable law about ministerial acts that may be performed by non-agents on behalf of the broker, like staff members. And that was just really just pulling straight from LREC rules about what broker staff can do. Duties of the broker, designated agent. Again, we just took the statute and kind of laid this out. We're not trying to create duties or obligations of any brokers that don't already exist. We're not trying to make things more difficult for you or create the potential for a claim or a suit or some liability by a buyer that you didn't, perform some duty or obligation. What we are trying to do is sort of just summarize for the buyer, these are the standard duties that are applicable, and these are the things that we're going to comply with. If for some reason you want to do more, you want to add to this, you are certainly welcome to do that. And you can add whatever duties you want to, but what we've done is kind of lay out the bare minimum that's required by law. And then underneath that, we've got the duties of the buyer. And this is important in our mind, because we want the buyer to understand what their role is in this transaction, what they're expected to do. And in some ways, the fact that they're required or expected to do it clarifies that the broker is not, right? So if we're saying to you as a buyer that, you're going to give us accurate information, that means that we're going to rely upon that information when you give it. We don't have to do independent investigation. If we're telling you that you have to find independent experts to help you with things like home inspections or title or survey or whatever it is you want to do, that's on you to go find those experts. We are not that kind of expert. That's not what we do. We are happy to give names and recommendations, but those kind of things are not the role of the broker to provide those services. So this list is meant to minimize types of claims that you might get that a buyer would say, hey, you didn't do this for me. And I thought that was part of your role, and I thought that was something that you would do. So again, hopefully limits the scope of any claims that buyers might make. And again, clarifies what you're expected to do. In this next section, section 8, acknowledgements, very similar. We are trying to clarify what are the respective roles of buyer and broker and designated agent throughout the transaction. What is each one expected to do? And we kind of go through that and, again, try to establish maybe not a bright line, but as much of a line as we think can reasonably establish in terms of what each side is expected to be doing. Moving down into non-compensation, obviously probably the biggest concern in the section is the compensation section. Again, we have taken lots of forms. We've tried to consolidate that into this section that allows for compensation. Number one, it's a percentage of sales price. Number two, it's a flat fee. And number three, it's any other form of compensation that you want to agree to. So buyer and broker can agree on any form of compensation you want. Nothing herein requires percentage of purchase price or a flat fee. The other blank is for you to be creative as you want to be. But obviously, a lot of people are going to use the percentage, and some will use a flat fee, and maybe there's a combination of both. But that hopefully clears up some of the issues, like Jim mentioned, of having a separate document where everybody spells out the commission. If you've got it in a listing agreement with the seller, that's clear about commissions and fees and payments. And now, when you engage on behalf of a buyer, you also have it in this type of agreement, then, not to say that the disclosure is not necessarily a bad thing, but this hopefully addresses some of those issues. The next section, section B, kind of goes into buyer's agent payment, which is, a commission fee or some similar payment from the seller or listing broker that is remitted to the buyer's broker. So this kind of gets into the commission split, kind of discussion and talks about what happens if that kind of payment is made to the buyer's broker and how that's treated as compared to Section A, which is compensation that the buyer agrees to pay to the buyer's broker, regardless of what the seller or seller's broker, anybody is willing to pay to the buyer's broker. Right. So to be clear, A is your agreement with the buyer about what you're owed. B is what happens if the seller or seller's broker is willing to pay some of the commission, and that's what addresses that. And you'll see in Section C, this deals with timing and when your compensation is earned and owed. And I think this is pretty consistent with what most folks have. You have the term of the agreement, and this term of the agreement can be whatever you want. That's in the next section, plus a period thereafter. And what we said is if the number of days are left blank, we're talking about 180 days. So if a closing occurs within 180 days of the termination of this buyer broker agreement, the commission payment would be owed. There is a prohibition on modification in Section D, and Section E deals with an issue that was raised by someone's comment regarding Veterans Affairs, which I think was touched on when Matt was talking. The Veterans Affairs loans do not allow for the payment by the buyer of any commission and does not allow for the funding or loan proceeds of any kind be used to pay for that. So there are issues with that, and we wanted to make sure people were aware of that. And so if a VA loan is used in a deal, that may need to be treated a little bit different. And I don't know all the ins and outs and details of exactly how that VA loan program works, but we did look at the rules and regs, and they are very clear about the inability of the buyer to be charged commission to be paid to his broker. All right, so then we get to the term of the agreement, Section 10. This can be anything you want. It could be 6 months, it can be a year, it could be 2. But we did put in an automatic extension so that, if there is no action to terminate, it will automatically extend for successive periods to make sure you've got a binding agreement in place, as long as you're working for that buyer to try to secure them a property. That being said, here's the termination right. The buyer can terminate, broker can terminate. Anybody can stop this relationship at any time, but that does not terminate the right to pay the compensation that is earned and owed. Again, if there's a closing within 180 days, you would still potentially be owed the compensation that is earned and owed, assuming you don't veer in terms of the number of days. We added this dual agency provision just to clarify, to make sure that's brought to the buyer's attention, that if a property comes up that the buyer may be interested in and suits the buyer's needs, for which the buyer broker is also the listing agent, that would be disclosed and that all the rules related to that would be followed. So we didn't go into great detail because those rules exist independently and you're required to comply with them, but we wanted to make sure it was brought to the buyer's attention and so that, it's top of mind for you as well. 13 is limitation of broker liability. We have done several things throughout the agreement to try to limit your liability, to make sure our duties are clear, to make sure that what we're expected to do is obvious to the buyer and make sure that what the buyer is expected to do is obvious to the buyer. So hopefully all that helps. In addition to that, we try to lay out some other instances where claims have been made against buyers brokers and tried to limit liability in those instances. And then we've just got miscellaneous things here. Most of them are typical. I'm not sure there's anything, we can sign electronically or by facsimile or email. If more than one person is named as a buyer, separate matching agreements can be executed. So those kind of things. We did add the electronic communications consent. So you can communicate with your buyer through email, and that buyer, acknowledges that. And passing scanned copies of things will suffice to be an executed document. And then, of course, we have a section at the end where you can add anything else you want to add. So to the extent this agreement does not address everything you want to address, you can put in there in the other terms if it fits, or you can just say, hey, see addendum A attached, and attach some additional terms if you want to do that. But again, this is a document that can be edited otherwise anyway, so you can insert other sections as needed. So that is a very quick summary. I'm happy to try to answer questions. You're muted, Ronald.
Do we have questions for Eric? You're getting off scot-free.
Eric, no, not quite. Eric, so when can we get a copy of this, or is this what you guys are recommending at this time? I mean,
yeah, so if it hasn't been distributed to everyone yet, it will be shortly. I think in the chat, Danielle put the link to where it will be. So this is,
and it has been distributed. It was redistributed after you went and made the modifications from the feedback.
and is it distributed to brokers or to every member?
Yolanda, Eric, this is Kim. It was emailed membership wide, like November 16th, and then it was included in the resource email on December 1st, and it can be found on the recent news under on the LR website.
is it still have the watermark on it, or is there one without the watermark?
It has the watermark on it, and all you have to do to take the watermark off is go into Word and remove watermark.
No problem. So, but
I'm pretty sure it went out in an email today as well at 2 o'clock. It went out statewide.
But
And I think
the forms.
that was the mandatory forms. But Jim, what was your question?
no, so it's ready to use. We can start. We can add this to our forms now, right?
Sure, and y'all can, like Eric said, pick and choose which portions you want, edit it the way you want, and fit your model. If you want just the compensation part, like you talked about yesterday, I think that's section 9. We'd recommend you look at all A through D, because we tried to take the best of all the different state forms. I think we looked at 9 different states to come up with this, and of course y'all's comments. And we tried to the extent we could to take as much legalese out of it, but it is a legal document, right? So there is some of that in there, but we tried to space things out, not have long, sentences and big run-on paragraphs and all that, and made it tried to make it easier to read. But it's there. Take the watermark off and do what you will with it.
And again, it's under on the website under recent news, our blog, and Donna posted all 3 links to the article, the best practices, and the actual agreement above in the chat.
All right, anybody else got a question for Eric?
I don't have a question specifically for Eric, and I'm not sure if it can be answered, but maybe taken into consideration for the next meeting, because I'm trying to understand, how does all of this impact value when we're marketing? That number, that price that's out there, is it going to then be based upon an appraised value, or will the appraised value be applied after the buyer pays compensation? So that buyer is paying price plus compensation. And I'm trying to understand exactly how we're supposed to market under these circumstances.
My understanding is the appraiser sets the value.
Right.
I'm not an appraiser. I believe there are some on the call who may be able to speak to how compensation is utilized in their setting of the value? Does any appraiser want to attempt to answer that question?
Yeah, this is Dax. I typically don't look at compensation too often because it's uniform, basically uniform across the board. You know, we still do look at concessions very carefully, but not so much compensation. But going forward now, I could see some scenarios that may affect value if you know, the structure of compensation changes, you know, as things are evolving after this litigation that has happened. So that's my answer.
So we really don't have a good answer for you. You should market the property the same way you've always marketed it. You do your comparable market analysis. You work with the seller to set the best marketable price and go forward. I mean, are you changing your value today based on what the seller is willing to compensate, whether they're sharing the commission or not? I mean, that doesn't change.
And I would also
I'm
add
looking
that
at that from the buyer's loan perspective.
That's a
appraiser go-
question. Yeah, that's
Yeah,
something
and
that
so-
that buyer's gonna have to discuss with their lender. If they are paying compensation, can they still qualify for the loan, and how does that work with the requirements of their loan type?
And Rhonda, to answer that, if they're talking to the legislative team at NAR, they are reaching out as we speak and have been before to talk to the national Fannies and Freddies and all. And certainly that discussion is going to have to get down to the state level to talk, because if there's in the future a dictate from a court, you know, that requires the commission to be paid by the buyer, then there's going to be drastic changes to the mortgage lending process, obviously, if they to change to roll that into the loan. So we're not sure yet. That's still open. It may not change, have to go to that, but if it does, certainly those discussions are happening now to determine how that even looks as we move into the future of where we are today.
All right, anybody else got a question for Eric? All right, I know Summer, you've been patiently waiting and having to hear all of this, and a lot of it doesn't have anything to do with the real estate commission. So I'm gonna welcome you. For y'all that don't know, Summer Meir is the executive director of the real estate commission. She's going to give you a quick overview of the purchase agreement and the disclosure documents, which were recently updated. Give us an idea on renewals and a preview of the mandatory courses for 2024 summer.
Okay, thank you all for having me. And, you know, even though we do not get involved with a lot of the discussion that y'all just had, it is nice to be able to listen and hear the input that y'all have put in. So, yes, for the mandatory forms, we, as most of you know, we do update the mandatory form agreements and the residential property disclosure document every 2 years. And we did just complete this a few months back. I would like to thank everyone that was involved in that standardized forms work group committee. That group included commissioners, myself, the rec staff, and attorneys. We had representatives from Louisiana Realtors, active brokers, title attorneys, and we received input from Louisiana Realtors membership, as well as our just licensees that are not members as well. The website has been updated with the forms. If you go to the lrac.gov website, under the forms tab at the top of the page, you then click on mandatory forms, and then you will see the links for the new forms. We do have the current forms on the website as well. Those will be removed after January 1st because there are some people that are still using those, of course. The new forms will be effective as of January 1, 2024. That will be mandatory. You will need to make sure that you are updating the forms that you are using in your offices to those new forms. So please be sure that you are changing over to those. We do also have on the website a video that was made by our current Commissioner Dee Halfin, who serves as chair for that committee, as well as former Commissioner Rick Roberts. They do go through a line-by-line kind of red line change of what's been changed in the forms. You know, we have Commissioner Rick Roberts on there, so that's our former Commissioner Rick Roberts. It is a little bit of an entertainment piece from him as well, I think, between the banter back and forth between the two. But it does give a good overview of what the changes are. And I believe Louisiana Realtors did also send out an email today at 2 discussing those changes. They do have a line by line kind of interpretation of what those changes are as well. So there's plenty of resources for you to take a look at to see what the changes in the forms were. And just remember, January 1, those do become effective. And if you'll have any questions at the end, I'd be happy to answer anything that I can. Kind of rolling into the mandatory course, generally, if we have changes to the mandatory form, we generally try to do a mandatory course that involves those changes. So the mandatory course for 2024 will be the mandatory form updates as well as a current hot topic section. So we will spend 2 to 3 hours on the purchase agreement and the residential property disclosure document. It will also go through just specific parts of the contract as well. It'll be updates, but also just kind of an overview of the contracts and forms also. And then about an hour to 2, depending on the current hot topics. As a reminder, that 4-hour mandatory course is required by all licensees, and it does have to be completed by December 31st of 2024. So if you renew your license September 1, you still have through December 31st to complete that course. There is no broker mandatory course required for 2024. The commission did not vote to do one of those for 24. So you're just going to have to remember to take that 4-hour mandatory and then your 8 hours of electives. And we are going to be looking pretty soon at what the mandatory course topic will be for 2025. So we love to hear from our licensees if you have any input on what you would like to see for a mandatory course, because you do need to sit through it. It needs to, protect the public is what our mission is. But if there are any particular topics that you would like to see, please send those my way. You can contact one of your local commissioners, let them know what you're looking to see. And I can put my email address in the chat in just a bit so that y'all can contact me with anything that you may have that you may like to see in those courses. Our current renewals are going on. This is a reminder that December 31st is the deadline for renewals. There is no grace period this year. If you do not renew your license by December 31st, as of January 1, you no longer have a license, and then you will be required to apply as an initial applicant. When you apply as an initial applicant, that means you have to retake your real estate exams. So if you have not done that, or if you have licensees in your office, please remind them that that does need to be completed by December 31st. Education also needs to be completed by December 31st as well. We actually have pretty good renewal numbers right now, but we are going to be trying to do a bigger push in the next few weeks. We do have about 15% of active licensees that are left to renew. And I do want us to give a reminder to brokers, if you have a company license as well, please be sure to renew that company license also, because the majority of your licensees are sponsored under that company license. And if you don't renew that company license, then your licensees are not going to be, their license will be considered inoperable. So please make sure to go in, that it is under your user ID and password in your portal. Go in there and look to make sure that you've also renewed that as well. We are looking to hopefully do a push as well, while we want to keep our licensees active. If there are any licensees in your area that are thinking about letting their license go, remind them that they do have the option to go inactive. They can renew and put that license in the inactive status. What basically that means is there's no continuing education requirements. You're not allowed to practice real estate at the time, but it does keep your license current to where you're not going to have to reapply as an initial applicant if you decide later to come back into business. I know with everything going on, there's a lot of uncertainty. So we just want to remind people that they have that option, so that they are not having to retake that real estate exam and go through that whole initial applicant process, which does include the digital fingerprint background checks as well. Reminder, keep your email addresses updated with the commission. That is going to be where we contact you for any issues with your license. So you need to make sure that that email address is always updated. If you'll also please let your licensees know that as well, so that they'll know to check that information also. And I think that covered everything I had to talk about. I talk really fast, I know, but I'm sure y'all have been on this call for a little bit. So I'd be happy to answer any questions that y'all may have. I think there was a question in the chat.
Yeah, it has to do with if you miss the renewal, do you have to take pre-licensing again?
No, you do not have to take the pre-licensing course again, as long as you can provide those certificates that show that you have that the 90 hour. We should have it on file as well, depending on how far back your license goes. So no, you do not have to take it, but you do have to, again, take those real estate exams and go through the entire process. For fingerprinting, we've been getting a lot of questions about fingerprinting. With the delays that were created with the Louisiana State Police, we have initiated with them a new digital fingerprint background process. So if you are going to either upgrade your license to a broker, or if you're coming on as an initial salesperson, you now have the option to get the digital fingerprints, which is what we recommend. You will go through on our website. There'll be the checklist that you'll go through. It'll give you the link to Identigo. If you've ever done like a TSA pre-check, it's one of those similar locations that you would go to where you get your digital fingerprints done. We get those results back in 2 to 3 days. Whereas if you send in a paper card to Louisiana State Police, they are so short-staffed that it's taken 60 to 90 days sometimes for us to get those results back. So that process is now in place. It's up and running. It has drastically improved the processing time. Does anybody have any questions about fingerprinting? Or anything else I can answer?
Yeah, I have a question.
Yeah.
It's Lori McCarthy. So, can you repeat what you said about, I just want to make sure that I have it right before I bring it to my agents, about not paying their dues before the 31st of December, they have to retake the test?
Yes. So
wow.
Our laws have changed, and about 2 years ago, our law changed to where our renewal process, our renewal times, the delinquent periods basically changed. Whereas before, your license expired December 31st, but you had through March 31st was a delinquent period. We no longer have those delinquent periods built in after the first of the year. So those now, we're on our second delinquent period at this time right now. It started on November 15th and it goes through December 31st. So December 31st, your license is expired. That's it. You don't have an option to do a delinquent renewal after that point, because we are currently in that delinquent renewal period.
Thank you.
Okay, you're welcome.
I asked you a question in the chat too. I was just going to say it too. Is there any, for the last several years, I've asked about new construction things on the purchase agreement, like adding things so that it would be more friendly for new construction. Is there, and I keep being told that you guys are looking at doing a new construction purchase agreement. Is there any talk about that, or adding it to the purchase agreement to make it easier on new construction purchases?
Yes. So we have not had that discussion. We've not had discussion of creating a new purchase or a new construction purchase agreement. We did, just like I said, do the updates to the forms. So we do always take suggestions, and if it's something that that needs to be looked at, then the committee will take a look at that. But no, there has not been any changes to that. To having just that purchase agreement form.
Hey, Lori, this is Norman. I want to let you know, there is, I believe, on the commission website, a new construction addendum.
Right.
Back when we were working through the purchase agreement, the home builders or anybody would come to you on a new home and they would say, I want to use my own contract. But as you know, the way the law reads, you have to start a licensee originally with the statewide contract. So we worked with the Home Builders Association and created an addendum that answers or goes through a lot of those issues they were having, et cetera, et cetera. So let us know, look on, and we let the commission share that on their site, and they have been, but there is a new construction addendum on the commission website. And let us know if that solves some of your questions, or if not, we can certainly work with the commission on putting together some language as recommended to put an addendum to the purchase agreement if you need it.
That would be awesome. I'll look it over again. The last time I looked at it, it did not address the things that we needed, but I'll look at it again.
Yeah, and we do have a number of suggested addendums on the website. Those are not forms that are mandated by the Real Estate Commission. They're just offered usually, as Norman stated, through Louisiana REALTORs or other places that we've received the forms from. So not mandated by us, but provided for use if you choose to do so.
All right, anything else for Summer?
Summer, I have a quick question. This might be a dumb question, but the property disclosure is now it's going to be updated. Do we need to at what point do we need to update those? Is it if the listing expires and then we relist it, we need to update it? Is that right?
Correct. After January 1 is when that form becomes effective. So if your listing does expire, you would need to, you're basically starting a new listing agreement, then you're going to need to update your forms.
But if I have a listing and it goes into February, do I have to update all the forms on every listing? It's just if it expires or I relist it, right?
That's correct.
Okay, thank you for the confirmation.
All right, real quick, I'm going to preview 2024 from an LR perspective. The leadership conference will be held at the Golden Nugget in Lake Charles, January 14th through 16th. We have Lee Brown and Terry Watson scheduled to present there with some CE classes. You don't want to miss either of them. They're both really phenomenal. Spring legislative issues and Realtor Day will be in Baton Rouge at the Hilton Capitol, April 8th through the 10th. On the 8th, the NAR At Home with Diversity designation course will be offered. Fall governance meetings will be held at the Hotel Monteleone, September 30th through October 2nd. There will be a short sale and foreclosure designation class held on Monday, September 30th. Other opportunities, there's a new home construction and buyer rep class on Tuesday, the 23rd. There will be a 1-hour lunch that's going to be provided. The RENE certification course will be virtual on February 28th and February 29th. The NAR Green designation will be virtual May 21st and May 22nd. The ABR designation course will be virtual October 23rd and October 24th. Those will all be posted to the LR website, so you can check the calendar there and look under events to get registered. And for lastly, if you guys have any feedback on the Zoom calls, topics you want covered, please, please, please email them to info@larealtors.org. We're working to plan the broker summit for next year. If you have a recommendation on where you'd like to go, what you'd like to see, who you'd like to hear, please send us that. It looks like the consensus for those of us who went to Houston last year would like to go back and do the ball game again. It was a great way to get out of the office and away from everything. We were not in a casino setting. You got the opportunity to network with other brokers and get 11 hours of CE, which was a benefit to everyone. So please, if y'all have ideas, please send them through the info@larealtors.org. And Jim Katie's going to go over all of that with staff next year because he gets to set all this up. And if y'all can't tell, I'm really happy about that. I'm excited for him to come on board and bring some new perspective to this. I appreciate everyone who is still on and stay with us to the very, very end. Again, we will try to get Matt scheduled or someone from NAR's legal team back early in the first quarter to update us again and answer questions you all may have regarding the lawsuits. Norman or Tony, do you have anything you want to add before we leave?
No, just if anybody has a threat or hint of a lawsuit, whether that's local association, MLS, or a brokerage firm, please immediately reach out to us so that we can help y'all assess and provide the appropriate support we can, provided that we're left out of the lawsuit. Also, please let us know, as Rhonda said, the topics you want to hear in the future. And I will say a new course, we were just able to get a 3-hour course on March 21st. Lynn Madison will be doing her version of where all this is going with the buyer representation and et cetera, based on everything changing in the industry with the lawsuits and otherwise. And I think that'll be a well attended course, and encourage all your agents to attend. And she's going to go through buyer representation and even look at our buyer rep agreement. As y'all know, Lynn Madison is from Illinois, and Illinois agency law, our agency law was patterned directly, if not word for word, after the Illinois agency law. So just a couple of tidbits before we get off.
I don't have anything. I appreciate everybody being on the call today.
Jim, you got anything you want to add since you're it next year?
No, but great job, Rhonda. We appreciate it. And we did have an amazing amazing year, and obviously we have a lot of challenges that we're going to be dealing with next year, and we need y'all's feedback and cooperation. So looking forward to an exciting and a collaborative year in 2024. So thank you guys. Any recommendations you guys have, any topics, we really want to hear from you. So please get it to the staff at Louisiana Realtors or me personally.
All right, well, thank you, everybody. We'll see you after the first of the year on the first quarter call.